So, in our last lecture, we dealt with the First Amendment freedom of speech clause. Now we're going to be looking, oh, excuse me, we dealt with the freedom of religion clause. We're going to be looking at the freedom of speech in this next lecture. So, we're just going to sort of pick up right here where we left off. And freedom of speech is very important in our society, and it has been protected on a large level. The clause in the First Amendment says Congress shall make no law abridging the freedom of speech or the press. And so it's been something that has been protected pretty severely by the Supreme Court over time, and it has been referred to as, freedom of speech has been referred to as the marketplace of ideas by Justice Oliver Wendell Holmes. And so if you have the ability to go out and make assertions and people follow them, then that is sort of like a marketplace and you are gaining followers. And so speech protections are held to a very high standard, and if government wants to regulate the speech, they must have incontrovertible reasons for doing that. However, there are varying degrees of protections based upon the type of speech that is exercised. But one of the highest protected types of speech is political speech. It has been consistently protected, and this was of the greatest concern to the framers of the Constitution. It wasn't as if they were concerned with you being able to say whatever you wanted to say. They were more concerned with the idea that people should be able to talk about the government and criticize the government if necessary without, repercussions. But the first modern free speech case was during World War I, and when in 1917 the Espionage Act came into question, and the Supreme Court upheld the Espionage Act on the grounds that individuals who constituted a clear and present danger were a menace to national security. But since that time, free speech has really been protected. Political speech has been protected, even if it is outrageous. And there are some instances in our society where there have been some outrageous instances where speech has been protected, and we're going to talk a little bit about that in just a moment. But there's other types of speech called symbolic speech, speech plus, assembly, and petition. And so this type governs speech-related activities, things like leafletting, demonstrations, generally anything that is designed to send a political message. And so these things are protected. And we're going to talk about some of these cases that have been seen in society as outrageous that have been protected. And the first that we'll look at is Texas versus Johnson in 1989. And it is the flag burning case. In 1988, the Republican National Convention had their convention here in Texas, and a protester outside this convention burned an American flag in protest to the Republicans. And Texas had a law that banned the desecration of revered items. So it wasn't even specifically targeted at flags, but because a flag was a revered item, it was protected under the state law. And so this individual was arrested because they felt like he had broken the state law, but the Supreme Court takes up the case, and they deemed this Texas law banning the burning of flags or other revered items unconstitutional because it was an expressive and protected. It was expressive and was protected by the First Amendment. So even if we don't see it as something that is very palatable to society, it's still protected. Another instance is Snyder versus Phelps in 2011, and we talk about this as the Westboro Baptist Church case. The Westboro Baptist Church is a very I don't know. It's a very, I hate to use a certain term to describe it, but it's sort of a fringe church, and it has some very interesting views, to say the least. But they were in the habit of picketing at soldiers' funerals. And they said they would picket at soldiers' funerals and say that because America had accepted homosexuality, then God was punishing America by killing our servicemen. And so they would hold signs outside of funerals of soldiers that said, you know, thank God for dead soldiers and things of that nature. Well, a soldier of a father sued Westboro Baptist Church, saying that he had been exposed to this in a time of crisis, and the Supreme Court declared that picketing was constitutional. Even if it was detestable, it is a protected form of free speech. So we don't really see it as something that we like or agree with, but it's protected. And so the Supreme Court really upholds this idea of freedom of political speech and symbolic speech. And then if we look at speech plus is any kind of speech given but accompanied by physical activities, things like sit-ins, picketing, demonstrations. It's protected, but it's conditional. And so if you are doing something that hinders public order, then you can be disbanded or you can be arrested. So it is protected, but there are conditions of protection. And then students, let's see, a speech by a public school student has been very limited. Limited free speech in public school systems by students. Students' speech can sometimes interfere with the school's goal of teaching students limits of socially acceptable behavior. And so schools actually do have rights to censor student speech that advocates or celebrates the use of anything illegal. And then, so the takeaway from this is that speech is extremely well protected. And so we turn to another type of speech, which is the press. And speech is protected against what is known as prior restraint or government action to suppress material deemed harmful in some way, or censorship. And the precedent was set by a Supreme Court case known as Neer versus Minnesota in 1931 that stated that the government could not prevent newspapers or magazines from publishing whatever they wanted. 40 years later, it was reasserted in the New York Times versus the United States in 1971 with the Pentagon Papers. The government tried to block the publishing of certain Pentagon documents, but the Supreme Court sued, and the Supreme Court sided with, the New York Times sued, and the Supreme Court sided with the New York Times and said that the government could not prevent or block publication of these letters, even though the person who gave these letters to the New York Times got them illegally. So even though there was some question surrounding the legality of how these things were originally gotten from the Pentagon or the government, the Supreme Court said, they can print and publish those. Now, one thing that is not protected, and there's been a lot of debate regarding this in recent times, but journalists cannot protect their sources. And so a journalist can be jailed for failing to give information in court regarding their sources. So as a journalist, you cannot protect the person who gave you the information. And so if you know who it is, you know their identity, and you are asked in court to give that, if you do not, you can be jailed for that. So you cannot protect a source. Now, as I said before, and I will say again, there are limited areas of protection. Nothing is absolute. And there are a couple of areas that are limited in their protection. Number one is libel and slander. And this is reckless disregard for the truth, damaging to the victim because it is malicious, scandalous, and defamatory. If you publish something, then that is libel. If you say something, that is slander. And so if your intent is malicious and scandalous and defamatory, and you mean to cause harm by saying it, you can be sued under libel and slander. It is not protected as free speech. However, it is incredibly hard to prove that there was malicious intent. So even though it's not necessarily protected 100% by the government, it can be very hard to prosecute. Another area of limited protection is obscenity and pornography. And this is defined as speech or writing that appeals to the prurient nature or the prurient interest or the interest that to incite lust of society. But the problem with obscenity and pornography is it's very subjective, because what might be debase language or action or lustful the incitation of lust to one person might not be to another. And so the Supreme Court has had a very hard time in defining what is obscenity and what is pornography. Even Justice Potter Stewart going so far as to saying, I don't know how to define it, but, quote, I'll know it when I see it. But there have been some attempts to define pornography as deemed lustful by the average person according to community standards, depicts sexual conduct, quote, in a patently offensive way, lacks, quote, serious literary, artistic, political, or scientific value, or defined by local, and it has been by and large defined by local rather than national standards. However, there has been court cases that have protected pornography in 1997 and 2011, and so there is this codified protection of a person's right to view pornography. So it does have limited protections. You are not going to be 100% protected, but you do have some protections should that be something you want to engage in. And then the third area of limited protection is what is known as, quote, fighting words. And this is the movement of expressive words from symbolic to actual conduct to direct incitement of damaging conduct. And so it goes beyond perhaps just what you're saying. Your intent is to cause damage, incite damage onto an individual. And this stems from a 1942 case where there was an arrest of a man who called a police officer, quote, and I apologize for the language, but a goddamn racketeer and a damn fascist. And he was arrested, and his arrest was upheld because the language that he had used, quote, had no essential part of any exposition of ideas. He meant to cause some kind of damage to the individual that he was utilizing these words towards. And so in 1951, there's a court case called Dennis versus the United States that said there is no public interest in permitting insulting or fighting words that tend to incite a breach of peace. So if it's words intent on starting a fight, causing damage, breaching peace, then you are not protected. But we are largely moving away from this. They have reversed every conviction utilizing fighting words as their argument for conviction. So the Supreme Court is really sort of moving away from this, but understand that you are not 100% protected. And interestingly, we have a case at the appellate level in 2019 that the Supreme Court has ruled that it is not against the law to flip off a police officer. And so the case was either in Minnesota or Michigan, and I can't remember which, but a woman was pulled over for speeding, and the police officer noticed that she had some other infraction. So he did not ticket her for speeding, but he did ticket her for whatever this other infraction was. And it was a lesser offense. It was a lesser charge. It was going to be a lesser ticket. But as they are pulling away, the woman flips off the police officer, and within 1,000 feet of their initial stop, the police officer pulls this woman over again and writes her a ticket for speeding. So goes back and, I was trying to be nice, but now I'm going to go ahead and give you the ticket for this infraction and for speeding. This was contested all the way up to the appellate court level, and the appellate court said that did not uphold her ticket for speeding under the argument that flipping someone off is protected as free speech, and so he did not have just cause to pull her over the second time. So there is some movement away from this idea, but it is not going to be an area that you are fully protected. All right, we're going to move on to the Second Amendment because there's a lot of discussion and controversy regarding the Second Amendment, and I'm going to go ahead and put it in this lecture because the next lecture is going to be dealing with some of your court rights and things like that. And so I'm going to go ahead and put Second Amendment in this lecture. But the Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, there are multiple interpretations of this. We're going to look at early interpretations and we're going to look at later interpretations. The early interpretations of the Second Amendment, as written, was meant to allow citizens to serve in militias to ensure protection of the country. And so the nation was founded in the 1800s. It was common to own a gun. It was almost a necessity in some cases. And the United States had just won a war utilizing a militia. And so the framers of the Constitution put into the Bill of Rights this idea that you can participate in a militia to secure your state. And this is different from a professional army at the national level. This is at the state level. And so it's okay for you to have be a part of a militia to secure your state. It's okay to have a weapon in the pursuit of securing your free state. But it was never really an issue until modern day. And so our later interpretations are going to be based upon Supreme Court rulings that had very little to no precedence that the Supreme Court could rely upon. And so really the only case up until the 21st century is going to be in 1939 when the Supreme Court offers a ruling that upheld the idea of the preservation or efficiency of a well-regulated militia. And so the lack of court involvement allowed for significant differences in gun laws across the nation. This wasn't something that was legislated at the national level. It was something that the states did. And so we had varying degrees. We do have varying degrees of gun laws across different states. And you can go from Wyoming, which has almost no regulations on guns, to California that is extremely highly regulated. And so it's not even going to be until 2008 that the Supreme Court is going to step in. In 2008, two rulings are going to be issued regarding gun rights, and they are going to be in favor of gun rights and expanding the view of gun rights from this well-regulated militia to this right for individuals to own weapons. And the first is District of Columbia versus Heller in 2008, and in a 5-4 decision, the Supreme Court provided that there was a constitutional right to keep a loaded handgun at home for self-defense. So this essentially expands the view of the Second Amendment to protect individuals who own a gun for the purposes of self-defense in your home. And then in 2010, we had another Supreme Court ruling known as McDonald versus Chicago, and in a 5-4 decision, it incorporates this Heller decision, to the state governments, meaning all across the nation. It created the right of individuals to actually bear arms. Because Heller was a District of Columbia case, it didn't incorporate that Supreme Court decision to states because the D.C. is not a state. But McDonald takes that next step, and it does incorporate this decision to all of the states. And so essentially it creates the rights of individuals to bear arms in their homes all across the United States. Now, that's not to say that you cannot regulate gun ownership and purchasing and things like that, because you can. Everything is regulated, folks. And that's what you really need to understand about the Bill of Rights and any of your rights. They're not absolute. They are not 100% free. They are regulated. Everything is regulated. Even as we looked at religion and speech, they're regulated. And so this is no different from the Second Amendment. The Second Amendment is regulated, and it can be regulated by the government. So understand that you do not have unfettered abilities and freedoms to purchase and own guns. There are regulations that are in place, and they could be in place at the state level. They could be in place at the national level. All right, so we're going to stop here, and when we come back, we're going to pick up again on civil liberties and hopefully sort of finish up this topic of study.